All right. Let's start off. We're going to start off with Senate Bill 250, and Council, if you just give us a recap of where we left off with the. I think was there an amendment before us, or no?
There was. The committee voted it unfavorable.
Got it. Okay. Just give us a recap, and then we'll start discussion.
So Senate Bill 250 repeals the exemption from prosecution for certain sexual crimes for individuals who are married at the time of the offense. There was an amendment that was considered yesterday. The amendment was voted on and voted unfavorable. There are two additional amendments that should be in your voting packet. The first amendment that we'll go through is Amendment 493125/1. That's for Senate Bill 250. The amendment number is 493125/1. So what this amendment would do is it would preserve the part of the spousal exemption that applies to fourth-degree sex offense, and the exception for offenses committed under 3303, 3304, and 3307 of the criminal law article would be repealed. So that's the first and second-degree rape and third-degree sex offense. I am.
So first off, Senator West has an amendment. I think we want to do that one. But also, when we left, there was a motion and a second on the actual title of the bill that Senator Carter had made.
I started off the meeting asking, do we have an amendment open?
Yeah, we were with Senator Carter made a motion and a second on the title of the bill. And then, before we get to that, Senator West had worked out language that he was talking to people about, so.
All right, well, let's do this.
So we don't need to get into mine right now. I'd rather pick up where we were on the motion in a second.
All right, so then let's do this. Senator
Carter,
are you pressing your amendment?
Yes, I'm pressing my amendment because I really believe that the bill the title should reflect what the bill does, and the title is misleading, and the title actually offends me because it doesn't even apply to what the bill does. Just to scratch off that caption of "love is not a defense." I mean, you could say marriage is not a defense. That's more honest. But
love is not a defense to. You mean the current title of the bill?
Yeah, I mean, if you want to say
And
marriage
what
is
do you
not a
want to
defense.
change it to?
Well, no, all you got to do is just strike the parenthesis language and
Yeah.
leave it as criminal law, sexual crimes, or penal spousal offense. Get rid of the parenthesis. Love is no defense to sexual crimes.
That's fine.
It's intellectually dishonest. It's.
Yeah, I said okay, so let's move it, right? I don't want to stay here for 3 hours.
Well, we're not going anywhere anyways, I hate to say.
Yeah, over a title.
All right, not a substantive change. Senator West, go ahead.
Thank you, Mr. Chair. Yesterday, when we had a long conversation about this issue, the fourth-degree sex offense issue, and it seemed to be the only hang-up people had, and I said I thought we could draft our way around this. So I drafted something, and I've discussed it with a number of people. I think there's broad approval, and I gave it to Jamie earlier. I don't know if you've had a chance to prepare a formal amendment, but it's only one sentence. It would appear in the definition of fourth-degree sex offense, and right now there are two. There's an exception section, and the first subpart of that is the familial affection language that we talked about yesterday. This would add a third subpart, again an exception to sexual offense, and it would say 3, the sort of intimate contact normally engaged in by two individuals in an ongoing sexual relationship until after such time as one of the individuals makes it clear to the other that the intimate contact should cease.
Can I comment first? Because, I'm a member of this committee too. Okay, I don't, hey, I'm speaking, okay? Let's have some respect here. Well, I do not support this amendment because I think the bill without amendments is fine without this, but this, if Senator West wants to offer this as a clarifying amendment, go right ahead. Maybe let's vote on it, okay? But I intend to vote against it, but let's take a vote on it.
All right, can you go ahead, just read it one more time, because I have it, but it's in your handwriting, and your handwriting is like my handwriting, so I'm having trouble reading it. I have worse handwriting, but just can you read it one more time?
I'll read it again. So it's in the section of the code which Jamie, I'm sure, can find, which deals with fourth-degree sex offense, and it's a third subpart to the exclusion or the exception, and it says 3, the sort of intimate contact normally engaged in by two individuals in an ongoing sexual relationship until after such time as one of the individuals makes it clear to the other that the intimate contact should cease.
I just wanted to point out, I guess the where that seems to be relevant is for the definition of sexual contact, because shows of common expressions of familial or friendly expression are excluded from the definition of sexual contact, but that definition of sexual contact actually is relevant not just in the fourth degree sex offense section of the code, but also in relevant to other offenses like third degree sex offense and the rape statute. So I guess you would be affecting, I think, more than just the fourth degree statute if you included that definition.
Remind me where this was in section 3. It was a definitional section, wasn't it?
3-301. It's in the supplement. You have the supplement in there?
I do have something.
Open up the supplement to page 37 or 36. At the bottom of page 36.
Well, we could change it. I certainly don't want to cause unexpected consequences. We could change it and say, for purposes of section whatever of the code, comma, sexual contact does not include, and then include the language I just read.
So I guess, and I think I was actually mistaken before. It doesn't apply in the first or second degree rape statute. But so it sounds like what you would want to do is for the definition section, I think you would put that in 3301, and
Tied directly
you would
to
say
this.
You would define familial affection for the purpose of section 3308, or only section 3308 means, and then the definition that you provided.
Isn't it section 318? It's not 308, it's 318, I think.
No, 318 is the current spousal defense. 3308 is fourth degree sex offense.
Okay, that's fine. Yeah,
Right.
yeah. Yeah, that's fine. It just would apply to section 3-308. Exactly.
So what can you explain again? What are you trying to solve? The passivity. Can you explain again? Just can you frame why your amendment's necessary?
Yes, there was, in our long conversation about the bill yesterday. There was the concern that a husband who rolled over in the middle of the night and began to touch his wife to initiate sexual contact, or vice versa, would be literally committing a fourth-degree sexual offense, or could be construed as literally committing a fourth-degree sex offense. And in order to avoid that possibility, if the other spouse had made it clear in advance that intimate sexual contact should cease, then it would be a fourth-degree sexual offense. But so long as the other spouse had not made it clear that sexual contact should cease, it would clearly not be a fourth-degree sex offense.
Like, if, let's just say the husband in this instance, husband, wife. You're saying the husband moves over, turns over in the middle of the night to initiate sex
Yes,
and touches his wife's breast.
yes,
She does not want to engage.
right.
And so you're trying to say that that is not a fourth-degree offense. You're trying to clarify that activity. You're trying to clarify that.
Yeah, until she said, I don't want intimate contact any longer, then before that point, it's not a fourth-degree sex offense. After she says, I don't want intimate contact anymore, from that point on, it would be a fourth-degree sex offense.
So I guess I'm asking, so she's obviously conscious and awake, and lucid, your scenario, right?
Yeah.
So do you remember, so I'm trying to square that with the Attorney General's opinion I got last year that cited the Travis v. State case. And then, so one of the line that stuck out for me was, in the case of a conscious and competent victim, mere passivity on the victim's part will not establish the absence of consent. That seems to me to take care of that scenario, but that's why I'm kind of struggling with this.
Yeah, I read that the Attorney General's opinion, and as is the case with most Attorney General's opinions, there was an awful lot of on the one hand, on the other hand, on the one hand, on the other hand, and I could not find in that opinion a conclusive statement that would apply to the hypothetical that we envisioned and we're talking about yesterday afternoon.
So was that his statement, the summary of the AG?
No, that's a direct, that's citing from Travis State. It's a 2004 Court of Special Appeals decision. 2014. Sure.
My understanding is, because it was said yesterday, which I thought was not correct, when the statement was made, no means no, my understanding of fourth degree offense has been an affirmative no is not required, rightfully so, because if you're on the metro or out on the beach and some creepo comes up and grabs somebody by the crotch, that's a typical fourth degree. The person didn't have to say no. You're not allowed, and that's why we created the whole fourth degree, because we didn't want it to be, we used to charge it as a second degree. We're like, no, we don't want that. We want to specify that this was a sex offense. And so we don't actually require an affirmative no to get it. And there's a good reason, because if the soccer coach grabs somebody by a young, someone under their control by the breast, we don't want that as assault. We want it as a fourth degree. So I think Senator West's amendment is trying to clarify this whole situation, because my understanding with fourth degree is an affirmative no is not required.
With that being said, if the affirmative no, why wouldn't we just exclude fourth degree sex offenses and then let everything else, anything that involves a felony, then we move in that direction? Why wouldn't we just exclude the fourth degree, that touching?
Jack.
Yeah. Did you call on me? Oh, thank you, Mr. Chairman. So I guess I'm.
Can we pay attention to Senator Hutton, please?
I'm not, with regard to this amendment, I'm not really sure how you define the sort of intimate contact normally engaged in by two individuals in an ongoing relationship, first of all. And second of all, again, it requires the victim to want to end the party's intimate relationship forever and not just to stop the action, which is, I think, what we're getting at here. And again, still, it treats unmarried and intimate partners who are living together differently. And I think that's the purpose of this bill, is to put them on the same level. Thank you.
Well, first of all, my proposed amendment doesn't say you need to make it clear that the sexual contact should cease forever. It just said should cease, suggesting that there could be a resumption of sexual contact after the two parties get together again. But I'm looking at the Attorney General's letter from last year, and this is what I mean. It says, evidence of a lack of consent is necessarily fact-driven in individual cases, but courts have discussed various circumstances that a fact finder may consider in determining a lack of consent. Among these factors include, and it goes on, and then on the second page, it says, for the purposes of factually determining whether there's a lack of consent by a competent and conscious person to an intimate partner's sexual contact, in my view, a court is likely to examine whether evidence demonstrates, and it goes on. So there is not a good black line here. It all depends on the circumstances. And what I'm trying to do in this amendment is give some reassurance to married couples or couples who are not married, but nonetheless in intimate sexual relationships, that when one partner touches the other in a fourth degree, in what otherwise would be a fourth degree sexual offense, so long as consent has not been withdrawn, the partner needn't worry about criminal consequences.
I just think that is a solution in search of a problem. I mean, I don't think that there's an issue there. I mean, again, these are each circumstance is different, and they do take a look at what the relationship and the normal course of the intimacy is between the two partners. So, again, I think we have to stick to what the purpose is of this bill, and the purpose is to treat unmarried couples and married couples on a similar plane with regard. It's good.
All right, so you've got an amendment, it's been seconded, we'll do a roll call.
Vice Chair Waldstreicher.
No.
You're a no. Oh.
Jamie, can you read the amendment as you advised?
So this could be subject to additional stylistic changes and conforming changes, but essentially the amendment would be going into section 3301 of the criminal law article, which is the definition section, and it would be providing a definition for familial affection with respect to sexual contact. And it would provide that familial affection with respect to only section 3308 of the criminal law article is the sort of intimate contact normally engaged in by two individuals in an ongoing sexual relationship until such time as one of the individuals makes it clear to the other that the contact should cease. Okay, until after such time.
So we want to define that as familial affection is going to be
You could say that because actually familial affection is probably broader than that. You could say that familial affection includes that, so it wouldn't be
I would hate to say that familial
exclusive.
affection includes touching somebody in the crotch. It's sort of a bastardization of the term familial affection. I mean, it's like, you know, amongst friends and family kind of affection. You know, father, daughter, sister, brother, whatever. I mean, I hate to. Can we do a definition somewhere else that would be?
Should it say for the purpose of this, just affecting this section, this part of, could we do it for just this part of the marital exemption? Just that part. This is only going to be on the section that had, well, I guess the dealing with just the marital exception.
It's a little tough to do this on the fly, but would the idea be to, in 318, which is the spousal defense, provide that or the spousal exception, provide that the exception only applies to a violation of 3308 between intimate or two individuals in an ongoing sexual relationship until such time as one of the individuals, until after such time as one of the individuals makes it clear to the other that the contact should cease. So it would still apply only to in the married relationship then.
Jamie, could I try it? Let me try it. So it's in section 3-301, the definitional section, the definition of sexual contact in subsection 4, subpart 2. Sexual contact does not include 1, a common expression of familiar or friendly affection, or 2, an act for an accepted medical purpose, or 3, and this is new language, for purposes of section 3-308 hereof, the sort of intimate contact normally engaged in by two individuals in an ongoing sexual relationship until after such time as one of the individuals makes it clear to the other that the intimate contact should cease. Does that work?
I guess the caveat that you might add to that, or for clarity, would be instead of saying until such time, just say unless. So
what?
unless one of the individuals makes it clear to the other that the intimate contact should cease, or that the contact should cease.
You want to delete the words after such time as?
I think it, just for simplicity in the language, I'm not sure that there's much of a difference there, but it sounds like it's important to distinguish that it doesn't apply after that has happened, that the individual has made it clear to the other that the contact should cease.
That's fine. Just take the words such time as out. That's great. Okay, you want me to read it as finally proposed? Okay. There's a new subpart 3 added to that section, and it says 3, for purposes of section 3-308 hereof, the sort of intimate contact normally engaged in by two individuals in an ongoing sexual relationship until one of the individuals makes it clear to the other that the intimate contact should cease.
Just offer a slight revision to that. Maybe say, unless one of the individuals has made it clear, instead of makes it clear.
has made, so put it in the past tense?
Right.
Okay, that's fine. Good. Unless one of the individuals has made it clear to the other that the intimate contact should cease, right?
The word intimate in there, I'm wondering if it's necessary because this is falling within the definition of sexual contact, so you may not need to, it may be surplusage to say intimate.
All right, I don't mind that. To take out the word intimate in both locations? Gotcha. Shelley, do you want to say something?
I have a question. Isn't 3308 about a person in a position of authority?
But what's prohibited under 3308, so looking at 3308B, it's a list of conduct that's prohibited and would therefore qualify as a fourth-degree sex offense.
So it
So-
doesn't have to meet the standard of A. It's separate.
I'm sorry, Senator.
It doesn't have to relate to A at all?
Well, A is definition, so that definition of person of authority applies in subsection C, which applies to,
The answer is no.
right.
Okay.
So if you
Fine.
if you have the book.
I'm looking at the online.
But basically, in subsection B1, the prohibition is a person may not engage in sexual contact with another without the consent of the other.
Right, which is why I'm wondering, it says it there. All right, can we?
Vice Chair Waldstreicher.
Pass.
Senator Lee.
This is on the amendment, right?
Yes.
No.
Senator Cassidy.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Vice Chair Waldstreicher.
No.
Chairman Smith.
No.
The amendment passes.
All right, bills before you as amended. It's a motion for a favorable on the bill. It's been seconded by Senator Heddleman. Roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
Pass.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Senator Cassidy.
Yes.
Chairman Smith.
Yes.
Bill passes. Favorable with amendment.
Okay. Have the three.
So this bill establishes the Notary Public Fund. The purpose of, oh, sorry.
360.
So Senate Bill 360, State Government Notary Public Fund, and Remote Notarial Acts. This bill establishes the Notary Public Fund. The purpose of the fund is to provide funding to support the actions of the Secretary of State in implementing, regulating, administering, and enforcing Title 18 of the State Government Act, Notarial Acts. The fund consists of money appropriated in the state budget to the fund and any other money from any other source and revenue distributed to the fund under sections 18-103B5 and 18-108B. The bill is not creating or altering any fees. These are existing fees relating to the issuance and renewal of notarial commissions and personal information requests relating to a notary. Those two sections that I just read. There are no amendments in your packet.
There's been a motion for favorable. There's been a second. Is everyone okay? Just holding it open for a second. Make sure everyone gets a chance to read. Okay. All right. All right, Bill's given it favorable. All right. Senator Jackson with Senate Bill 607. Do you still want to do that right now? You want to do that right now? All right, let's discuss.
So Senate Bill 607 prohibits a person from intentionally or recklessly killing, injuring, or interfering with the use of a service animal. Violation is a misdemeanor punishable by imprisonment of up to 5 years and/or a $5,000 maximum fine. Violators must also pay full restitution for all damages arising out of the offense.
Thank you, Mr. Chairman. And when I spoke to you earlier, we have, and I'm trying to find it in my many pieces of paper here, should have an amendment. The House passed the bill out, Judiciary passed the bill out with some amendments. Okay. No, actually, we're looking to actually conform it to the House. So, what they did, they essentially, I think one of the challenges was that during the hearing, or maybe not during the hearing, but the House reduced the penalties. And I thought I had my amendments right in front of me, but just looking to conform it to the House bill. What's that?
Interfere with seems to be the same penalty. It seems like if you kill somebody's service animal or injure them, I can clearly understand that. But if you interfere with, what is that? I don't know what that means. I don't know that. I'd like to see what the House did. That interfere with is a little bit concerning, that part. Media control, interfere with the use of a service.
Senator Jackson, I'm not seeing the amendment, but was the were the?
He just sent it.
You did? Okay. So, as amended by the House, it would provide that a person may not willfully and maliciously kill a service animal, or allow an animal that that person owns or over which the person has immediate control to kill a service animal, injure a service animal, or allow an animal that that person owns or over which the person has immediate control to injure a service animal, or interfere with the use of a service animal,
What does that mean?
or allow an animal that the person owns over which the person has immediate control to interfere with the use of a service animal. The penalty is also lowered in the House amendments from 5 years to 2 years and from $5,000 to $2,500 maximum penalties. It also provides that a person who violates the prohibition on interference with a service animal is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 1 year or a fine not exceeding $1,000 or both. Instead of being mandatory that the defendant pay restitution for all damages, the court may order the defendant convicted to pay full restitution.
So here's my concern. So it's just like when they have the police dogs, and usually these dogs have signs on them, do not pet. Well, is interfere, am I missing, is there somewhere it's clearly defined what that means? Because if you pet those dogs, you're interfering with them. Or some teenager, some kid throws them a treat or something, you're interfering with that dog. Is it defined in this bill what interfering means? Well, I mean, that's concerning to attach a criminal penalty if some kid walks up and starts petting a service dog, or if I stupidly go up and pet the dog or talk to it and interfere with the job. You're not supposed to do that. It's an impolite, wrong thing to do, but that's not a criminal action. So I would suggest, unless it's clearly defined, we should strike the interfering part and just leave it at kill or injure.
Second, I kind of try to see why they made that. Was that part of the amendment? No. It was part of the original language.
The House did not amend that act.
Got you. No, I'm good with that. If there's no definition, Jamie, is there a definition, or does Senator Wallstreicher want to?
I don't want to fashion a definition, just strike it out.
Okay, that's fine.
So I would move that we adopt the House amendments with the exception of, or I should say, in addition to the House amendments, we strike the interfering language and we adopt the House amendments.
So this is a question for both Senator West and, Senator Huff and to the sponsor. So we're creating a new crime from whole cloth, which is fine. That's part of why we're here. But Senator Huff, I know you and I are on this kind of crime classification, and at some point we should start standardizing it as much as possible within us on a going forward basis, even as we're looking backward. And to me, misdemeanor is always defined as a year or less. And in fact, yesterday, when we were doing with people who can sit on a jury, that was like the dividing line. So I don't care. I don't know.
You're right in that it catches collateral consequences on firearms and all kinds of stuff when you go over a year. So you're exactly right.
So if I could amend the amendment, if you're open to the, Senator Huff, we would go to 1 year and then the definition that you indicated.
Yeah, I would second that.
Okay.
So we're okay with that?
Okay.
That's good.
I just wanted to push back a little bit about the interfere. Oh, we took it out? All right, take it out. Bye.
Okay.
I agree with taking out the penalty. I disagree that petting a dog or a horse would be impacted by this bill, so long as we're changing the bill to say a person may not willfully and maliciously interfere with. Nobody who pets a
It's
dog.
already, yeah.
All right, fine.
Go ahead, Jackson.
Move the bill as amended. thank you. At least we don't have the therapy turkey with us, you know. So, you know, the young lady tried to get on the plane with it, with the,
So, as introduced, this bill establishes numerous requirements to govern the use of facial recognition services by units of the state and local government. There is an amendment in your packet. It is number 743624/1. So this strikes the bill and instead establishes the Task Force on Facial Recognition Privacy Protection.
Thank you. So, given the concern that we have with the way that facial recognition is being used, but given the fact also in listening to some of the way that it's being used by the state, there was some concern about the legislation that I put forth, but there was also interest in putting together a task force so that we could talk about some of the issues that I was attempting to address with the legislation. So we've reached out and have everybody that you see down there within this task force are interested parties and parties that want to help to come to some best practices so that I can introduce some legislation next year. So the panel is made up of the State's Attorney's Office, the Public Safety and Correctional Services, which has the I believe it's called the MERS program, the Public Defender's Office, State Police, as well as the Center on Privacy and Technology from Georgetown, which has done a lot of work in this area. We have a professor from Johns Hopkins who's involved in doing this. Microsoft as an industry, security industry associations who came and testified on the bill, as well as the chiefs and sheriffs, ACLU, and Lawyers Committee for Civil Rights.
All right, okay, moving the amendment. Seconded.
Can I ask a question? Sure. I'm just curious, why did you pick just Microsoft?
With them, they were. I worked with them on the legislation, and honestly, in the time that we had, that was one of the industry players that we just had a relationship with, and trying to cobble this group together.
I guess just a quick question on council. Do we, because we don't normally have, Josh's council, I'm sorry. Is there any problem listing one specific company?
I don't believe there is. I don't know if anybody else has particular experience, but I'm not aware of an issue now.
Okay.
Are there any like weird?
Well, I had
Are we going to give them any sort of unfair?
I don't know. I had a constitutional issue once on something minor like this. That's why I was curious if it's better to say a technology company, but
I'd rather not mention a specific company. Because also, like, I don't know if they could use that later on as marketing, like we got, I don't know.
Or they start fighting, and all of a sudden Apple has a lobbyist show up here, and then they're probably watching right now. I should be quiet. Oh God,
your iPhone's gonna seize up right now. Your laptop's not gonna work. Your face, they already captured your face.
I'd like to retract that. I think Microsoft's an excellent corporation.
All right, so you consider that a friendly amendment?
Friendly.
Okay, you got it, Josh.
So I'm thinking, so you would strike Microsoft Corporation and say a manufacturer of facial recognition technology? Yeah, so the bill would establish the task force on facial recognition privacy protection. So the task force would consist of a number of members whom Senator Sidnor had detailed, including, rather than a member from Microsoft Corporation, one member from a manufacturer of facial recognition technology.
Adopted. It's been motion, it's been seconded. Is everyone okay? All right. Let's go, Josh, we'll stick with you. We're going to go to Senator King with Senate Bill 435.
This bill repeals the authority of the Motor Vehicle Administration to suspend the registration of a motor vehicle because the registered owner of the vehicle incurred a toll violation and failed to pay the toll and any associated civil penalties. The bill would take effect June 1st, 2021. The department did not take a position, but they did submit a letter of information which did discuss that they believe that this is an important tool for enforcement.
Yeah, I mean, how are you, it's funny, this bill, you did? Because I remember, I thought this bill used to go to finance. And I only say that because I think I got stuck behind watching it once in finance waiting for a hearing. Am I wrong, or is this?
Well, so I had a version of this bill that related to, I think, red light cameras. So what the MVA is doing is they're getting out of the business of suspending people's licenses and registration, but getting into the business of not renewing it. In other words,
Okay. So you can pass this, they won't suspend it, you just won't renew you then.
they just won't renew you.
All right.
So you just wait out the 2 years, and then they say, hey, you didn't pay this ticket, you got to pay it in order to renew. So it's a less active thing that the MVA does, and then you pile up your the merits, and then you go in to re-register, and they say you got to pay your $90 to do it. So that it just time shifts.
So I'm just going to keep running this. When I keep running them, I'll just put it in like a little investment fund and just pay it when I re-up.
That's right. That's right.
So does this go on to the car or the driver? Currently, I mean, suspending the it's a registration of motor vehicle, so it's not the person's registration, it's the vehicle registration, right? It's not your license.
If it would go on the vehicle, not the driver's license.
So what we're saying is, this is already being done. They're not they're just not re-registering.
So currently, if you don't pay, they have the ability to suspend the registration. And with the bill, they would lose that ability, but when you came back to re-register, they would be able to refuse that, which they can already do.
I'm just troubled by why we want to take this power away from them. So I buy a car every 2 years, and I just never paid the tolls, and I go to register, the car's gone. I sell out of state, and I come to the next one, and the next one, and the next one. I never pay tolls. At some point, they catch up to me, and they say, okay, we got you on this game one. We're suspending the registration because you do this all the time. What if they're not doing? I'm not sure what we're correcting. The problem we're correcting, if they're really not doing this actively, but why do we want to take the authority away? Is the MVA's not coming in saying, well, we're not going to do this anymore, so let's do a correction to the statute? They're not.
The answer is, I think you're trying to limit law enforcement contact. So you get pulled over, your registration was suspended, and now you've got criminal consequences associated with that. I mean, I'm sure that you're not getting taken in, but you get pulled over on a suspended registration, there are consequences to that. So I think the idea here is to try to limit law enforcement contact over failure to, pay your video toll ticket, and instead make it more administrative.
Why do I want to limit law enforcement contact with some schmuck who's driving the tolls for free and I'm shelling out money every time?
Except if you registered your car at one address, moved a year later, forgot to pay a $4 toll,
Right.
and then, they're sending the ticket to one house that's not getting forwarded to the other house, and then you get pulled over because you have a registration suspended that you don't know is suspended. Suddenly you're in a combative thing with a cop, like, I didn't get that ticket. Yes, you did.
But didn't we take some action? I'm like Senator Huff. I thought we did something to correct that you wouldn't just be suspended lightly, that there was something, other steps in there? Is it, or we didn't correct that already?
So, a little point of clarification there, if you could just help me with this. So most of the time, the reason that the MVA did this way I understood it was the fact that when somebody wouldn't pay their registration, they often were not paying their insurance. So, and if you don't have a valid registration, you don't have valid insurance. And that's why they had this issue. Because if a person does not have valid insurance, but they're still driving around on a valid registration, and they're involved in an accident, right, without the valid insurance, then that falls back to the taxpayers and not to them financially. I think this is an issue that I think we should really look at what we're trying to do to not avoid law enforcement contact with somebody who's not paying their bill. Is this in turn going to create a larger financial burden for the legal taxpayers?
This is triggered by the failure to pay the video toll, which is the Easy Pass. I don't know exactly what the correlation between that and not having insurance is. I could look into that. I don't know that we have those numbers.
Okay.
So I'm looking at the fiscal note, and it says that it flags, MDTA flags registration for a suspension when the vehicle's license plate has $1,000 or more in unpaid tolls and penalties. So is that what we're trying to do with this bill? Like, right? So that's like, seems like a different scenario than what the vice chairman. I mean, that's significant.
Because that came up before. We're like, wait a minute, you're not going to be arresting people because they didn't pay one time. And that stuff. I thought there was something done. Sounds like what we did before.
Yeah, so you run it for like 2 years, you got like $2,000.
Now, it says that's the practice, but
Actually, she's got the ICC, right? I think.
Thank you, Mr. Chair. It's even worse than that. I'm on the second page of the MTA's information letter. They say repealing the MDOT MVA's ability to suspend the vehicle registration when an individual has reached the $1,000 threshold will only exacerbate the outstanding amount of toll debt owed, increasing the likelihood that the customer's account will be referred to CCU, where they will be charged the additional 17% collection fee. So I'm not sure it's doing them any favors to allow them to continue to rack up larger and larger amounts of money, including a 17% collection fee.
Unfavorable. Hey, look, 17%, if that's over, I'm assuming that's annualized. I'm just hoping that's like a massive credit card bill you're racking up for 2 years. You don't want to hold that off. That's not helping anybody. roads.
Senator made a motion, it's been seconded, so we'll run it.
Actually, there's a serious policy thing there.
Go ahead.
More, just real quick.
It's Josh, it's his council.
Yeah, it's not a council question. I actually have a serious point, is that tolls actually, they're like gas taxes. They pay for your roads. And we actually, for things like the ICC and these ones that are public-private partnerships, actually the collecting of the toll is very important. It pays the concessionaire to make sure they have the money to build the road. So you really literally are freeloading if you're driving on these tolls in some situations and not paying, because the tolls need it to pay for the actual road. And, you know, we're talking about trying to fix the American Legion through a public-private partnership. That's going to use toll concessions. So actually, I don't want to make it so people don't pay tolls, because it's what keeps the roads going. So people don't like it. It's unnecessary, but it's, you know, it's a necessary evil in that we need to pay for the roads and things like that. We all have to pay gas taxes when we put that gas in the car. We don't have a choice. And another way to pay for transportation is tolls.
What's the triggering point? What's the number? Go ahead, you, Josh.
The triggering point in the statute is simply that they failed to comply with a citation for failure to pay. But I think in their letter of information, they say their practice is until you get to $1,000 in unpaid fines, they're not going to do this.
So they're saying they don't do it until you get to 1,000. That's what they said. That's their testimony. Okay. All right. So we still have an amendment open. We still have a motion open. It's been seconded, so we'll run it. But we got Senator Hedelman and then Senator Jackson.
So somebody just told me that you can run up $1,000 video toll pretty quickly. So I guess my question is, if that happens rather quickly in the matter of days, how much time, how much leeway do you have to be able to pay it before they suspend your registration under this?
I believe the citation would be 30 days. So it's just to be clear,
quick.
I don't know about to pay the toll, but to pay the citation, I believe would be 30 days that you pay or you elect to contest the citation.
And then how much time after that can they suspend your license, registration?
I believe until you would then come into compliance with the citation by paying or electing to contest in district court.
So. Right. Like.
Toll for not a commuter rate, just a straight toll for the harbor, for just the 95 tunnel, that's 333 trips. And they only, because that's round trips, because they only do tolling one way. So that's a whole year's worth. It's more than a year's worth if you're doing 5 days a week. So you're really being deliberate about that.
Thank you, Mr. Chairman. So I remember this bill. I just got over here, and Al Carr had this bill. I'm sorry, Delegate Al Carr had this bill probably every year since we've been in the House. I'm looking at he's a cross filer, and they finally passed this bill. Okay. Relax a little bit, man. But I think like today, I think all the bridges in Maryland are heading to, you don't have to have the easy pass or get in the lane, and I think it's like $250 a car or something like that. So it's going to take you a while to get to 1,000. Some of us travel across these bridges a lot. I think that if it doesn't trigger until you're at $1,000, I think that was probably part of the issue in the past of when it triggered to suspend someone's license. I'll be voting against the unfavorable. Say that again?
Your argument sounded, the motion is, the motion is an unfavorable.
Oh.
You argued against the bill.
No, I will be voting for the unfavorable.
Oh, okay.
What did I say? I said I'll be voting against the unfavorable. I think when he interrupted me, I probably got to that point. So
sorry. I'm trying to break you. Don't look at them house votes, man. Don't look at them.
Vice Chair Waldstreicher.
No.
Senator Lee. This is Senate Bill 435. The motion's unfavorable.
It's unfavorable?
That is correct. That's
Unfavorable?
All you gotta do is say yes or no.
Okay. Well, you don't always do that. Okay. Good boy, Go ahead, Castley.
Are you passing?
Yeah, I'll come back to me, okay?
Okay.
Yes, because for the reasons that Senator Jackson, that's 333 trips on the harbor, on 95. So that's a year's worth, because they only bill one way. So, and so if you're going to work, it's like a year and a half worth of blowing off the tolls every day. So, yes.
Senator Hedelman.
So I was initially skeptical of this, but now I am learning that if you have an easy pass and there's an issue with your credit card and the ICC in the Montgomery and Prince George's area, which is not my neck of the woods, but that you can rack those fines up pretty quickly. So I vote no on the unfavorable.
Senator West.
I'm going to pass.
Senator Sidnor.
No on the unfavorable.
No? Okay. Senator Jackson.
Yes.
Yes for the unfavorable. Senator
Yes.
Bailey. Sorry.
Yes.
Senator Carter.
No on the unfavorable.
Senator Huff.
Yes, and explain my vote. I have an easy pass. I regularly drive all the way from Frederick County down to DC, and I think at most I do $100 a month because it automatically refills. I don't know that I've ever had a month where I did 200. I've never, that's in a whole month. I've never heard of somebody $1,000, and I regularly hit tolls all the time. So yes.
Senator Castley. Oh, sorry.
You mean
Senator
me?
Lee.
No.
Senator West.
I've driven the ICC during rush hour once or twice, and that costs a lot of money. So I'm going to vote yes on the unfavorable.
I think it's $5.
I think it's
Yeah, it's like $5.
The unfavorable fails.
So the bill's on hold then, right? No. I think the chair wants to hold it. He said.
All right. Never gonna see that bill again. All right. We're gonna go Senator King, the other bill. Let's go. Senate Bill 535.
So Senate Bill 535, Condos and HOAs Meeting Requirements. This bill establishes procedures for an HOA to call an additional meeting of the governing body if there is not a quorum of lot owners at the meeting. The bill makes clarifying and technical changes to the corresponding provision in the Maryland Condo Act. Under the bill, an HOA or a condo may hold the additional meeting if the original meeting notice contained the date, time, and place of the additional potential meeting. The additional meeting must occur no less than 15 days after the initial meeting. Notice of the additional meeting must be provided in a certain manner, no less than 10 days before the additional meeting. There are no amendments.
Can I ask a question on this one? So not being part of any condo HOAs, can somebody just, in layman's speak, say what the impact of this would be, and I mean, I don't have any upfront objections, but I would like to understand whose ox we're goring and who I might piss off or not piss off.
So currently, these procedures are not, they don't exist for HOAs, but they do exist for condominiums. So that's the first thing the bill is doing. It's mirroring the HOA and the Condo Act so that they match. These provisions do currently exist in the Condominium Act, but it's providing clarification about how the notice can be provided, the timing of the notice. So basically, if the condo or HOA is having a meeting, but there isn't a quorum present for like lot owners, there aren't enough to have a quorum. So they say, okay, so instead of having to like recall and redo the whole meeting again, they can say, well, when we put out notice for this initial meeting, we provided that there's a potential additional meeting if we didn't have a quorum. So then this bill specifies the timing for that additional meeting in order so that way when they can do it in the 15 days, they'll have a quorum present.
Calling a meeting on the 3rd, but if we don't get a quorum, we're going to reconvene on the 31st.
Exactly. So it's clarifying those provisions and then matching the condo and HOA.
Okay. If I didn't go on the 3rd, I just have to assume there's a follow-up on the 31st.
Sorry, what?
I said if I didn't go on the 3rd, I would
They
just
have
to...
notice provisions that they have to follow. So like if one of the examples that they gave are possible notifications is they can post it on their website to notify the lot owners that the additional meeting is actually happening.
Just a lesser notice requirement. You already gave the full notice. Okay. Thank you.
You're welcome.
It's been seconded. How does everyone feel? Good. All right. Bill is given a favorable. Yay, Senator King. All right. Let's go on to, Senator Jackson, Senate Bill 750? Yes. Okay.
This bill authorizes the Charles County Board of County Commissioners to establish and provide for the administration of a community service program and a pretrial release program in the county. As specified, a court may order a person to participate in either program. So in your packet, you have an amendment that was adopted by the Judiciary Committee to the House cross-file. So that is House Bill 1072, and the amendment number is 192018/1. So this amendment strikes the provision allowing the county to enact a local law on eligibility for the pretrial release program, and the provisions of the bill that establish eligibility requirements for that program. And it additionally allows an agreement to provide for the program staff of the pretrial release program to notify the sheriff of any violations.
Yes, thank you. The amendment in front of you should be 802118. This delegation bill, and what it does is actually well, one's technical, but the other is the sheriff did not want to be the one who made the decision on a person's violations. What they do is they report that to the courts, and then the court sends the information regarding the person's pretrial release. So, move the amendment. Josh, you have it? Yes.
Who's got this one?
Good.
It's yours? Okay. So I thought most courts have like one of these programs. Do we have to have a statute for each one of these? How's this work? I thought most counties have a pretrial release set up? Or community services program?
This kind of program would be done by the county, and Charles County currently does not have one.
But I realize, okay. This is required in order to set up one of these programs.
Yes, I believe so.
Okay. I mean, I'm just used to seeing community services programs in all the counties, and
Courts generally do have discretion to order community service, but in terms of allowing, an option for something that they could actually, a specific program that they could be, sentenced to, I believe that would have to be done by the county or some other organization.
okay. All right, thank you.
All right, so there's been a motion to move the bill. Is everyone seconded? Is everyone okay with that? Okay. Bill's given favorable with amendment. All right. Let's do,
I just think this wasn't finalized on that night, so let me just make sure that's been finalized.
311. Let's shuffle.
This bill establishes a statewide, or as introduced, this bill establishes a statewide 311 non-emergency telephone system under the Maryland Emergency Management Agency. There is an amendment in your packet. It is number 333320/1. This would strike the bill and instead establish a work group to study and implement a statewide 311 non-emergency telephone system.
I'm just saying we're running out of numbers. We pretty much used the whole 1-1. Yeah, we just went 2-1-1. We're, okay.
Steve made it a motion. Can you get it, Senator Jackson? Sorry. Go ahead.
Sorry, Mr. Chairman. This bill came out of, it's one of the, that came out of the work group, the 911 commission that's been going on for I think we have the third or fourth year, but not every jurisdiction has this, so move favorable.
So it's a couple $1,000,000 every year. How are they paying for this thing?
So I don't know, under the bill as drafted, that has the fiscal impact with the amendment, it would simply establish the work group. Correct. The amendment would strike the rest of the bill.
Be blunt, I guess because you can't Google and find your local police department number? It's a non-emergency. You don't need to hit 911 as emergency. You just need it. I'm just curious though. Work group, because it's gonna come back next year as a bill for $4 million. Why can't you just Google or look up the phone number for the police department in your area? The reason you have 911 or these other things is an emergency. The mental health one, all these other ones. Why do you need a non-emergency number for immediately, quickly like that?
You're asking a question, why do you need 311 for an emergency?
No, if it's a non-emergency, right?
non-emergency.
I just call over to my police department.
It's an informational line. I mean, I'm not sure if Frederick has a 311 line, but Prince George's has a 311 line. So Montgomery County has it, and I think they're looking to do a regional piece. So I think we have a motion in a second.
Good. You have something to say? You want to speak on it?
I do share Senator Huff's concern. The 911s, all those make a lot of sense to me. And the 311 makes sense to do it by county So Prince George's has one, any county wants to pay for it, but to consolidate that on a statewide basis seems crazy because we know that all of our counties operate so differently, and you want an operator or a group in your 311 station that lives in your county, and they know all the peculiarities, the weird stuff about who you call for what. So I have no problem with the study group to do 311. I just hope that as they look at that, they'll really think about why this should come back to a centralized, when you consolidate like 911 things, that's because we send police and fire across the lines. Who's ever had a fire truck? It's important to have that. But these are, where do I get my leaves picked up? Where do I go for parking permits? This should be by county. Thank you.
Senator Castley, those questions and many others were brought up, and that's the reason why a bill was not proposed this year to actually implement it. The work group came out of that, so that's it. No, I'm here. I got you. Thank you.
Motion seconded.
Bob and I are going to serve on that thing.
Is everyone okay, or does anyone want to vote against it?
I don't want to.
All right.
On it.
All right, so,
Because you know what, it's going to come back next year and be a tax on cell phones like her 911 bill was the year before.
all right, so everyone vote off? Okay, good. All right, everyone vote Mike. Yeah. All right, we're gonna go to 8:42 now, so let's do Senator Sidnor. Do you want to do your facial? Your Jeanette genealogy? Yeah.
Are we going to 187 now, or are we going to?
right, you know what? Hey, he's still reviewing some of this stuff, so we're gonna come back to it. All right, just hold off on it then. All right. So next we'll just do Senate Bill, all right, so Senate Bill 892. We'll have council explain, and then Vice Chair has a comment.
So Senate Bill 892, Real Property Residential Lease, Fees in lieu of Security Deposit. This bill authorizes the landlord and a tenant to agree for the tenant to pay a fee in lieu of a security deposit that is in any amount and at any interval and partially or wholly non-refundable. The bill applies prospectively.
Thank you, Mr. Chairman. I commend the sponsor, Senator Augustine, for bringing this forward. This is a really cool idea. It lowers costs for tenants. It's a new industry. It's something we need to be looking into. I'm not sure we can do it this year, given everything we're doing in the kind of landlord-tenant area, but I hope we can keep the idea alive. And I know the industry is looking to work with the advocates over the interim. So, Mr. Chairman, I would motion that we move this to summer study.
All right, that is an actual motion, interim study?
Sure.
Seconded? All right, it's in. All right.
I'd like to do that.
Senator Benson, Senate Bill 842.
So Senate Bill 842 establishes the work group to study the assessment, treatment, and available resources for female youth in contact with the justice system. It is to be staffed by DJS. There are a number of tasks for the work group, but among these, the work group must review existing programs, treatment capabilities, and facilities for females committed to the supervision of DJS, and how DJS is responding to the increase of female youth participation in violent delinquent acts. By December 1st, 2021, the work group must submit its findings and recommendations to the Governor and General Assembly. It takes effect June 1st, 2021, and terminates June 30th, 2022. There is one amendment from the Prince George's County Senators. The amendment is to add the Secretary of Public Safety and Correctional Services.
Yeah, sorry about that. I just wanted to comment on the amendment. We did vote it favorably out of the Prince George's Senators for that and for the amendment.
Is that a delegation bill? It is. Okay, so it's a delegation bill, and you have a delegation letter.
Yes.
It's a delegation bill? So this is just for Prince George's County?
Is that right?
No, they're looking at more than just Prince George's County, but it came out of the Prince George's County delegation.
This is, okay, so just can someone help me understand what's going on? So I know that the Prince George's County delegation voted favorably. There's a delegation letter assigned to it. But it's a statewide bill, right?
Well, it's a work group.
Statewide, I mean, okay. A work group that's being proposed by the delegation?
I think that's how it reads. Jamie, is that how it reads?
Right.
Is that,
But it's a statewide implication, I mean, yeah.
Right, they're looking at more than just Prince George's County.
Senator Carter.
Oh.
Mr. Chair, so I think everything that the bill suggests is worthwhile. However, the Juvenile Justice Reform Council is continuing its work and taking up additional issues that we weren't able to get to over the last 2 years because of the pandemic. And thinking about what President Ferguson said yesterday about, all of the extra work and work groups and task force and commissions and all the things we do in the interim, I would like to propose that we simply add this additional assignment to the already existing Juvenile Justice Reform Council, which Senator Jackson is a member of, Senator Smith is a member of, I'm a member of, and, there's already like a large number of stakeholders that are already involved in it. I think this is all valuable and worthwhile and important. I just really don't think we need to create an entire separate entity to address it. So that's what I really believe. What do you think?
Second. So is it, I'm just trying to figure out the scope of it, because it seems like they're studying state stuff, but it's all Prince George's County people and it came out of the delegation, so it's like a very interesting. But go ahead, Senator Jackson.
Could I take a second to find out? I think that sounds proper. I mean, I guess I'm still on the work group now that I'm over here, unless Senator Huff's going to take my spot. But if I could have a second on that, I'd appreciate it to check with them. Thank you. Thank you. I'll be right back with them.
So go to Senator Jackson.
I don't think you want to step on anybody's toes. It's possible that the Prince George's County delegation was just looking to look at within their county, and if that's their interest, I don't have any problem with that. I think if we do that, that would ought to say on the title to the bill, Prince George's County. I mean, because it reads, the whole title thinks it's statewide. If it's going to be Prince George's County, if that's what we end up with, we really put Prince George's County in the title of the bill. Here's my recommendation. So it's clear right up front, this is not a statewide.
I mean, even if they thought
You know
of
better
it,
than I would just think.
It really is a much larger issue than Prince George's County.
The bill's going to be a statewide bill.
Yeah, children that are involved in the system, girls, females, they're statewide. They're not, I mean, the policies are the same throughout the state. Why wouldn't we deal with it as a statewide issue?
I'm fine. Okay.
I don't know. First of all, I'm in favor. I'm a big proponent of work groups and stuff. I'm not a proponent of unnecessary ones.
And I just know that sometimes delegations want to go into their counties and say, what are we doing here, and sniff it out a little bit. If that's all they're trying to do, I wouldn't have any problem with that. It's just that the bill ought to be titled, we ought to have the name Prince George's County in the title of the bill, if that's what this is about, so we don't get the misapprehension that it's a statewide bill. If they just want to go in there and check their own county out.
What I'll say is, there are no female facilities in Prince George's County. There are very few in the state. So I think I'm just trying to work on getting clarification on what the intent was here. I know that was on our list, and I should be back before we hit the floor, so I should know. So, thank you.
So Senate Bill 420 makes a number of changes to the statutory provisions related to controlled paraphernalia. It also alters penalties for offenses involving controlled paraphernalia and drug paraphernalia. Just walking through the bill, it alters the definition of controlled paraphernalia to repeal from the definition a hypodermic syringe, needle, or any other object or combination of objects adapted to administer a controlled dangerous substance by hypodermic injection. It also alters the prohibition on use or possession of drug paraphernalia. Specifically, the current law provides that unless authorized under this title, a person may not use or possess with the intent to use drug paraphernalia to plant, propagate, cultivate, grow, harvest, compound, basically things that are involved in the production of controlled dangerous substances. But it also prohibits possession with the intent to use drug paraphernalia to inject, ingest, inhale, or otherwise introduce into the human body a controlled dangerous substance. So it repeals those things relative to drug use, like injecting, ingesting, inhaling, or otherwise introducing into the human body CDS. It also alters the penalty of that section. It's currently a misdemeanor with a maximum penalty for a first violation of $500. For a second violation, the current penalty is 2 years, $2,000 maximum. This lowers that to 1 year, $1,000. It alters the drug paraphernalia statute to repeal prohibitions related to injecting, ingesting, inhaling, or otherwise introducing into the human body controlled dangerous substances, also lowering the penalty from 2 years to 1 year, to $2,000 to $1,000. With respect to controlled paraphernalia, it alters the statute to, I'm looking at page 3, lines 23 to 31, removes references to manufacturing, distributing, or dispensing CDS. And for that offense, the maximum penalty is lowered from current 4-year $25,000 to 1 year, $1,000.
All right, so it removes the criminal penalty for, looks like heroin, paraphernalia, needles, syringes, correct? And then second, on page, I guess this is 1, it removes the penalty for injecting, ingesting, inhaling, basically using drugs too? Page 2, lines 13 through 15. What is it striking? Or inject, ingest, inhale, the brackets around there does what?
Right. So what that under 5619, that prohibition says that a person may not use or possess with intent to use drug paraphernalia, and what's being removed is to inject, ingest, inhale, or otherwise introduce into the human body CDS. So that's the purpose for why it's being possessed or used.
Thank you. It's been a long time since we heard this bill, and I'm even a little foggy on it. It seems like 1,000 years ago with all of the heavy lifting that we've done. But one of the most compelling aspects of the testimony, in my opinion, was from members of the Baltimore Harm Reduction Coalition, and they reminded us that we passed legislation to allow for the safe and healthy distribution of a lot of these supplies to drug addicts, but that they themselves and their workers are often at risk because it's still technically a crime to be in possession of these things. And so part of the impetus for the bill is to make sure that those workers are kept safe and free from the harassment, as they talked about. That's not my word, it's theirs. Harassment and often of law enforcement and others. They also other people testified about just the cleanliness of our public areas, and that being another issue, that when people feel like they could get, nabbed by law enforcement, they often have to disperse quickly, and leaving these supplies and these needles and, paraphernalia around. And so much of the testimony we heard was that it's safer, it's healthier. And I'll finally just remind that, there was no opposition to the bill. It was a bunch of different people favorable, including like MedCai and I think some hospitals. I can look. I believe. It's that second reader in the House anyway.
Well, let me take a quick question, Senator Huff, first, which is, so I agree with you, Senator Carter, the people who are doing this, who are part of advocacy organizations and providing safe opportunities and safe paraphernalia is really important. But that's why I was confused by the bill, because I believe, and counsel, please correct me, that a portion of the bill decriminalizes the sale of these items.
No.
And it seems like you would want to maintain that so that people go to the free providers who are providing free, clean.
It doesn't, if there is something that you see, and I'll go to
Well,
the
I'll
bill
pull it
later.
up. When I remember reading it during the hearing. I could be wrong.
I think you're wrong, because it's all about decriminalizing the possession of paraphernalia and making it a lower penalty if someone is caught in possession. If it says it, that's not the intent of the bill. This is the second or third time the bill's been introduced.
Yeah.
We've actually never brought it up to discuss it for a vote before, but, it really does seem like a reasonable step in the right direction.
Do you mind
I
if
know
we-
that when the bill first came in a couple of years ago, it included other things like scales and things that could be used in distribution of drugs, but all that has been taken out of that bill this year. It's just the low-level stuff.
Can we ask counsel, is that okay?
So on page 2 of the bill, between lines 24 and 27, the current law does prohibit, it says, unless authorized by this title, a person may not deliver or sell or manufacture, possess with intent to deliver or sell drug paraphernalia, knowing or under circumstances where one reasonably should know that drug paraphernalia will be used to, and I'll skip forward to the part that's removed, inject, ingest, inhale, or otherwise introduce into the human body a controlled dangerous substance. So it would affect that prohibition.
Senator Carter, if that wasn't your intent, I think we want to keep that in. Current law.
I have a question.
Policy intent. Okay, so you're going around and these vans are giving free needles or whatever, and you don't want to prosecute for them. But we don't know where they got them from. I may be outdated here, no one would agree with me, which is fine. But you show heroin is a major problem out in the rural parts of my district, major still. And so you roll up on some young people, they've got the paraphernalia and stuff. I mean, isn't there something to be said for being a misdemeanor and getting them in the system so you can at least get them into treatment and services? Because I know they can say, oh, here's a card. We're not going to charge you, but please go into treatment. Please go get help. They'll be like, yeah, whatever. Thanks. We don't care. If you're totally removing any sort of criminal penalty, how do you get anyone to go seek any help? When you come up on young people who are using, if you come upon some 16-year-olds who have heroin needles now and spoons and everything, cop can't do anything under this bill. Right? Can't, call their parents, can't tell anybody.
That's not true, because, I'm sorry, but all this bill does
How's that not true?
is deal with the paraphernalia. I mean, if they
No,
have
if they came
drugs-
with, no. I said if they came up with you come across a 15-year-old and a 16-year-old. You got some used syringes, they've already shot up, let's say. They got some syringes, they got spoons, all the paraphernalia, but there's no drugs. They've just used them. Or maybe they used them a day ago or whatever. It's in the car. Cop rolls up on these young people that got it. Isn't there, I mean, this clearly, the first penalty doesn't even have, it's not even a jailable offense. So it's not like we've got a collateral consequence where we're locking people up. But don't we have a public policy want to have some sort of criminal penalty attached where the cop can call their parents, try to get them in the system, try to get them to treatment? Because when you totally decriminalize, there's literally, the cop's like, okay, I see it, have a nice day.
So first of all, if there's any amount of drugs whatsoever, which there will be when there's used syringes, police will absolutely arrest someone for having residue. That's a thing, and this bill doesn't take it out. This bill is talking about the paraphernalia associated with it, and as I spoke about before, so I won't sound like a broken record, much of the testimony was from the people that are actually in the delivery services of these things to keep people safe. It's really a public safety bill. And Jeff, Mr. Vice Chair, in looking at 24 to 27, I would say that all of the words outside of deliver should be struck, but I think deliver should be kept in to the extent that that's what these organizations do, is they deliver the paraphernalia.
Can I just respond back to that? How do you know that every piece of residue would be gone? If you just have some used needles and a burnt up spoon, you don't know that every single piece would be off of there. That's a hypothetical. That's not a statement of fact.
I didn't say it would be. I said it's probably not going to be off
You said
there.
probably, but the hypothetical I laid out is true in existence, and it's completely decriminalizing it. So I just think that's a bad move, but that's my opinion.
Senator Carter, where are you talking about delivery?
So Jeff or Jamie read page 2 D1. I think wasn't it D1? Yeah. Unless authorized under this title, a person may not deliver or sell or manufacture or possess with intent to deliver or sell drug paraphernalia, knowing or under the circumstances where one reasonably should know that the drug paraphernalia will be used to, and then do all these things. That's what I was saying. And so I think that,
Take out the brackets. And then she said, well, she wants to strike deliver from the current law.
That would also affect the items used to plant, propagate, so in the cultivation and growth of, that would fall under that.
Well, I think possess with intent to deliver, because if you are in the needle distribution business, you got to possess it with an intent to deliver it, which was a whole reason for the argument on the bill. I mean, for the reason that people argued for the bill. Not the whole reason, but a big part of the reason.
Now, it's not just the delivery, that you can manufacture and sell for the purposes of injecting, inhaling, ingesting, that this would legalize manufacturers and sale. Right?
No, it's not saying take that out. But let me just say this. As a person who has encountered people that have been arrested many times, people are always arrested, always, when there's residue. Police will say, I saw this or that, and there was residue, or what appeared to be residue, in the midsection of the car, or whatever. So this is not even designed to get to drugs. If there's drugs or residue there, they'll still be arrested under the normal course. This is all about the paraphernalia associated with using it. And again, it was brought by the people that are legally authorized by this legislative body to dispense it to people, because we believe that this is a public health issue more than the need to criminalize people for it.
So I'm confused, because if they're already legally authorized to do that, how could they possibly be arrested for doing what they're legally authorized to do?
So there was whole testimony on it. Like I said, this was a long time ago, but I mean, I'm happy to pull up the hearing
I mean,
again.
because look, I would have no problem with an amendment to this bill that says if you're authorized by the state to hand out needles or whatever it is, that you can possess those, and I guess we could put a quantity on there. You have a tractor trailer load, but
So there was definitely testimony that the people that work for, like Baltimore Harm Reduction,
Right.
have been harassed by police and arrested. That was part of the testimony that I remember. But there's a lot more that they testified to that I don't.
yeah, sure.
I thought we okayed it. It's been in the budget for 20 years.
Yeah,
It's
so
been in the budget since 1998 to do these heroin needle programs.
like back with needle exchange programs and
No, I mean, I thought
other
we've
stuff.
already dealt with this. This hasn't been an issue. They've been doing it for 20 years.
If they say it's an issue,
This is the illegal ones out there. Nobody's arresting these drug vans that go around. Now, once they take the drug van needles and they go out and start shooting up heroin, I guess there could be their liability. And that's what they're trying to get at, is they want to just say, well, there's no liability, whatever, for having heroin needles and paraphernalia, and next year we can just legalize using heroin.
I'm having a hard time figuring what we're trying to accomplish by this bill. Heroin is illegal, cocaine is illegal. We certainly don't want to encourage people to take cocaine or heroin. And we're talking about the paraphernalia that is used to administer the cocaine and the heroin. Why would we be trying to, I don't understand why we would try to decriminalize this to begin with.
there's actually, I think for like the last 20 or 30 or 40 years, been a movement throughout this entire country to begin to treat drug addiction as a public health problem more than, rather than criminalize that. And so this oftentimes, the fact that paraphernalia itself, just the possession of paraphernalia, is still illegal, even though we have decided that it's okay to distribute paraphernalia by certain organizations, the fact that it's still illegal, the people that testified, that are the dispensers, distributors of this legally, testified that it's a problem for them. But I want to be clear, I'm not claiming it's only a problem for them. I think it's both. I think it's a problem for them, and it's a problem for the people that they're out there trying to serve.
Then why don't we pass a bill which decriminalizes the possession of this stuff by organizations which are in the business of trying to deal with the addictions and get people unhooked, rather than just generically decriminalize all the stuff?
Well, that would be nice if we had availability of treatment so that we could supply treatment on demand, but I think everybody knows or should know here that that's not the case, that we don't have treatment on demand for everybody, available space for everybody that needs treatment. So in facing the reality that there are still going to be people that are going to be using drugs illegally, some of the things this body has done, for example, is the Good Samaritan rule that said that if someone, for example, dispenses drugs to someone and the person ODs, they can call the police or take the person to the hospital or whatever, and they won't be held accountable for it because we believe that's a safety thing. That's an extreme there, but it's a part of our recognition that using drugs and drug addiction is a public safety issue more than it should be criminalized. So this is another step in that direction. I'm a little caught off guard because of the fact that I'm confused that anyone still has this kind of like 1970s thinking and doesn't understand early 80s thinking, and does not understand that it's a public health crisis, and we don't want these people that are drug addicts being hauled into jail and accruing horrific criminal records. We want to get them help and treatment, and a lot of these programs are helping them or trying to help them.
Well, that's why I said, why don't we decriminalize this stuff in the possession of people? All right, so that,
that are
It's in the fiscal note. I'm just reading
part of the program absolutely testified that it is a problem. And I think that what they said is that they may not always have whatever the credentials or card or whatever they need to have on them at all times. And if they don't produce that, then they absolutely can be arrested and are arrested. So that's the thing. I mean, I'm annoyed at being put in a position of having to retestify for what this committee already heard, because we heard these things, I heard these things, and to be honest, it was pretty compelling. So I can't do justice to what the people that are out there in the streets every day trying to save lives testified to. That's not what I do.
I just disagree. I sat through the hearing. I didn't agree with them during the hearing.
So this is this drug issue. It's all of our districts. It's not an urban issue. I mean, all of our communities are impacted by the loss of life. And I am probably every member of this committee has toured. I would bet has toured the various groups, and we stood up our county with donations plus county funding and grants. Stood up a major coordinated center in my county to deal with addictions. And we meet with the parents who have lost their children and spouses who have lost, kids who have lost their dads or moms. These are really serious issues. But the one thing that keeps coming back, I think either Senator West or Senator Huff mentioned it, is we do see how many times they won't get the help. And their family knows it. They know they have an addict. And it's often using the arrest for these paraphernalias that lets the court get a hold of them and make them go get the treatment. And it's very effective if you can, but they're not going to do it on their own until, sad to say, until it's a judge saying it's you're in the jail cell or you're in the treatment room, you pick it, where they'll actually commit to the treatment. And so I'm not interested in rolling up addicts. Everybody's moved away from that. Filling your jails with addicts is so wrong. You've got to put them in. They have a medical condition, but you only do that as a last resort to push them into treatment. So I just don't want to. You refer to like a 70s attitude or 80s attitude, whatever that is. I'm saying this based upon not 70s or 80s. What I saw this past year. In the interim, it's just looking at this stuff. This is serious. It's scary, and what I've seen is these are the great tools because mom and dad can turn Junior in and say, "Look in her purse," that kind of stuff, and that gets you the in. And nobody's looking to put her in jail. Nobody wants to put their daughter in jail. That's not where we're going with this stuff. So let's just whatever we do, we just need to move carefully because a lot of people's lives are at stake, and this is not a political thing. This is a scary one. Thank you.
So what I'd say is, first off, with all due respect, Senator, this is not a police issue, right? The fact is, these things are illegal. And trying to say that cleaning up outside and not having all of our outside areas and not and doing that because of the fact the reason these people are dropping needles and they're doing other things is for fear of being arrested. That is far from the truth in my experience and when talking to these people. They are much more worried about being arrested or ripped off by another person than they ever are of being arrested by a police officer. Right? That is what these people will tell you when you talk to them. And you said, and I know, I mean, you are a criminal defense attorney. You are clearly going to be around these people that did illegal acts more than the rest of us, right? That is what you're going to do by your own admission and your career. But the fact is, what we're doing here by arresting these people that have these issues is not something to say, well, I don't want to be around these people anymore, so we decriminalize it. Makes no sense to me.
Oh, thank you. I've already talked, so I was happy to defer. But so briefly, I stated before, but I'll restate that there's a plethora of favorable testimony There's not one piece of unfavorable testimony. And I wanted to just take a snippet out of one of the testimonies that was submitted to us by MedChi, for example, that said that this bill would help to ensure that people that are accessing services such as syringe service programs and will avoid unnecessary arrest and incarceration, that decriminalizing this paraphernalia will provide greater incentive to seek treatment, as people who are using substances will be less afraid of law enforcement interaction. In decriminalizing paraphernalia, the state will also reduce the need for people to reuse certain items that may contribute to the transmission of infectious diseases. This will have a positive public health impact on the spread of HIV and hepatitis C. Further, the collateral damage and unnecessary incarceration continues to harm people, blah, blah, blah. We know about that. And what we also know is that when people are arrested for the paraphernalia, and be clear, I just feel like I need to emphasize, we're not talking about the drugs. This has nothing to do with possession of drugs. This is the paraphernalia. We know that they're not going to be most likely prosecuted, but it's an interruption. It still causes them to have to go be arrested, be processed. All of that whole issue with seeing the commissioner being held, disrupted, all of that happens. Ultimately, in many cases, if it's only paraphernalia, the case is likely not going to go anywhere. It's not going to be prosecuted. They're not going to be found guilty. So it's really just kind of a waste of an entire process and resources. And for that reason, I'm going to suggest, as we roll back to where we were a little earlier when the vice chair mentioned the section that included sale, I'm going to suggest that we strike that word and move the bill. Thank you.
Yeah, so I'll just make it kind of an official motion. So I would move that we remove the brackets on page 2 that refer to sale of this product. So I'm sorry, I'm looking, it's a little hard to piece together the way, but on line 27, again on line 28, line 30, and line 32, I think we would remove those brackets or strike those brackets, however is best referred to.
So that would return it to the current law, or would keep the current law. So the delivery, sale, or manufacture or possession with the intent to deliver, sell, or sell drug paraphernalia, knowing or under circumstances where one would reasonably know that the paraphernalia would be used for those purposes, would remain exactly as it is. You would just be striking the brackets, like Senator Waldstreicher said, in lines 27, 28, 30, and 32.
Yeah, my only thing would be for like marijuana, but
That section
is that carved out?
So if you go up to the line 7 on the same page, it says this subsection does not apply to the use or possession of, right.
Thank you very much. You got that open, Senator Hedelman, and then we'll entertain the amendment.
Well, I wasn't speaking about the amendment, so if you want to go ahead with that. Well, I was looking at something, at a piece of the testimony too from the Maryland DC Society of Addiction Medicine, and I thought the part that I found compelling was that they say that Maryland law currently allows for the sale of needles and syringes and other paraphernalia by pharmacies without prescription to patients showing proper identification and indication of need. Given the legal ability for individuals to purchase paraphernalia from pharmacies, it's appropriate and proper that the criminal code conform to allow individuals to possess these same items. Passage of this bill would create clarity for law enforcement officers and has the potential to increase the adoption of successful strategies like the LEAD program, the Law Enforcement Assisted Diversion Program within the criminal justice community. So, I mean, I do think that this is really about the public treating addiction like the public health issue it is. So that's all I wanted to say.
sell needles to diabetics.
Yeah, you don't want to, don't worry. Before us. Is everyone okay with that, or discussion? Is that a yes? I'm sorry, I'm just gonna take it, all right, so it's a yes. All right, now the bill's before you as amended. It's been, this motion has been for favorable, it's been seconded. Should we do a roll call?
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Is this for this bill for the paraphernalia with your amendments in it?
Yes.
Okay. Yes.
Senator Castley.
Pass.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Senator Castley.
No.
Chairman Smith.
Yes.
Bill passes with amendments.
Bill passes with amendments. Okay, great. So look, we're going to be on the floor in 10 minutes, so we just give folks some time to get something to eat. Just real quick though, all right, so I'm going to hold Senate Bill 504, which is still working on some amendments with folks. For the landlord-tenant evictions filing, Senate Bill 530 and Senate Bill 154. Senator Heddleman and I have been working with folks on B&T. We've been workshopping this stuff on and off the floor. Looking at the House bill, you know that you noticed today that Senator Gazone's bill with the abandoned property to fund MLSC was on the floor today. So that's part of this whole kind of a tripart movement. So we're working feverishly on that. So folks are going on and off the floor. We're taking meetings. We're doing that. So I just wanted, just for the folks watching, I know that that's happening. And so it looks like if we're not coming back on Saturday, it looks like we'll be back twice on Monday for floor sessions. That's what I'm hearing. I don't know. More guidance on that. So with that, let's just make sure you get something to eat before floor, and we'll continue on. Let's do. I don't know. I haven't heard the bells yet, so you want to do?
Yeah, so Senate Bill 360 is Senator Rosenkopf's notary bill. Senator King's condominiums and homeowner association meeting requirements. No. I'll do it. Carter. Senator Sidnor, your facial recognition. Senator Jackson, criminal law harm to service animals. Are you good with that? Yes. Okay. Senator Kagan, Senate Bill 631, Public Safety Statewide 311 Non-Emergency Telephone System. I'll take it. Senate Bill 750, Charles County Senators, Charles County Community Services and Pretrial Release Programs Authorization. Senator Jackson. And then Senator Carter, you want your drug paraphernalia bill? Yes, ma'am. Okay.
How about the 250, the sexual crimes, repeal of the spousal?
Yes, who would like that?
Senator Lee.
Senator Lee. Okay. Great. Thank you.